societies to be democratic have to be genuinely inclusive, that value difference and respect the dignity and equality of all human beings, regardless of difference. The disability rights movement is therefore in tune with a deeper and broader movement to create genuinely inclusive societies for all. It has been described as the next generation civil rights movement. I'll skip over the portion which I had thought I should read on the international developments on disability rights, and just focus on a few areas which usually I think get overlooked. This is the ILO recommendations. Often in a discussion on disability rights, the recommendations of the International Labour Organization are overlooked. The reasons for this are rather obscure. Apparently this is on account of such recommendations not being ratified. The earliest on this issue is a recommendation of 1955. Then we have the discrimination, employment and occupation recommendation. I'll just read Article 6. It says, application of the policy should not adversely affect special measures designed to meet the particular requirements of persons who, for reasons such as sex, age, disablement, family responsibility, or social or cultural status, are generally recognized to require special protection or assistance. Then we have the human resources development recommendations, which focused on the importance of providing vocational training and guidance, and the need to aim national goals, ensuring that employers are duly sensitized to that end. Some of the areas relevant for the purposes of this discussion are contained in Part 2, which are the principles of vocational rehabilitation and employment policies for disabled workers. I'll just read Article 4, which again talks of the same theme. The preceding articles talk of a policy, need to have national domestic policies, and Article 4 says, this policy shall be based on the principle of equal opportunity between disabled workers and workers generally. Equality of opportunity and treatment for disabled men and women workers shall be respected. Special positive measures aimed at effective equality of opportunity and treatment between disabled workers and other workers shall not be regarded as discriminating against other workers. So we had this affirmative attempt to make special measures. Now this theme was carried forward in subsequent conventions and recommendations. And we have the Vocational Rehabilitation and Employment Disabled Persons Convention of 1983. Then as late as last year we had a Human Resource Recommendation number 195, and so on. A very comprehensive convention was one in 1983, which followed the International Year of the Disabled. It enjoins all stakeholders to adhere to the principle of equal opportunity again. Now, why do I read this? Now, some of these recommendations have not been ratified or signed by the Government of India. Nevertheless, in my mind, they have relevance, because the Supreme Court has been increasingly saying, and this has been said right from the year 1980 onwards in Jolly George Workies, that rules of customary international law or accepted standards evolved by international organizations, though not being primary sources for construing municipal legislation, can be looked at for guidance to the extent they are not inconsistent with Indian law, particularly while interpreting fundamental rights and liberties. This was said in 1980, it has been said again in 1997, then again in 2003, 2004. Now I'll just pass on and quickly give a small presentation on some of the important. We have in 1990 in the United States there was what is known as the American with Disabilities Act. There's a large body of case law both in the federal courts and the US Supreme Court. The US Supreme Court has delivered about 18 judgments. These Americans with Disabilities Act was enacted in 1990. The US experience is a mixed bag. Some of the recent judgments have left disability rights advocates wondering whether a rethink is necessary on fundamental issues. The judgments, particularly of the US Supreme Court, have somewhat watered down the scope and reach of the enactment. In a judgment called the Toyota Motor Manufacturing case, decided in 2002, the court limited the applicability of the enactment itself to disabilities that impair performance of life activities. So we have, I'll just read out some of the interesting judgments, a summary of these judgments, which gives an idea of what are the kind of problems the court has been looking at. In Toyota, for instance, a factory worker's carpal tunnel syndrome was held not to substantially limit in the major life activity of manual tasks. Now this came in for a lot of criticism because that is the way a very conservative society looks at disability. Then we have a more beneficial judgment called the Cleveland versus Policy of Management Systems, delivered in 1999, where the plaintiffs claim that she was unable to work to collect the claim that she was not able to work to collect social security. That was her claim, that I don't work, I can't work, therefore I am claiming social disability benefit. In spite of that, she went to court and claimed discrimination. That the court said that this did not prevent the employee from also claiming that she could perform essential functions of her job with reasonable accommodation for the purposes of ADA. However, she had to give an explanation on the discrepancy. Then similarly, the court has taken a more proactive approach and said that even though in an employment contract an employee signs an arbitration clause, nevertheless the Equal Opportunity Commission, which is charged with the duty of overseeing the enforcement of the Act and also has got the power to bring actions in courts, that commission can sue on his behalf. So we have a third party who can intervene on behalf of a disabled person who might have signed that in the event of a dispute I will go for arbitration. In another case in 2002, that is US Airways Incorporated versus Barnett, the court said that reassigning an employee to another position is presumed to be an unreasonable accommodation if it interferes with the established seniority system. So these are all basically cases on employment, and that was one of the comments made by the previous speaker. I think it's well taken that most of the case law that we look and do come across deal with employment related cases. But there are some interesting cases, but I'll just read two of them. One is the use of a golf cart in a tournament. So one of the disabled persons was unable to compete along with the others. He wanted to use a golf cart, whereas the rule said that you have to walk down. So the Supreme Court said there is nothing wrong. The golf cart would not fundamentally alter the nature of the game and he should be allowed to do so. Similarly, access to public accommodation in a foreign ship which entered the territorial waters of United States was also held to it was held to be necessary to comply with the Act. Then you have I come to the United Kingdom, where also there has been an enactment, one comprehensive enactment in 1995 called the Disability Discrimination Act. It's been working for 10 years. Now there is another legislation in 2005. Now here the experience is somewhat broader, and that's perhaps also because the legislation is itself wider. I'll again not go into the details of the employment related cases, but I'll just say this, that the court has said that the cases need not, even in relation to employment legislation or employment provisions, the employee's rights do not necessarily get limited to the duration of the employment. What are called as long-tailed provisions are, for instance, if an employee leaves an organization he may be entitled to a certificate. That cannot be withheld. For instance, if the employer gives a facility like a membership to a club, that cannot be denied even if the employee leaves the employment. Now that is the kind of law which is interestingly developing. I don't think I should take up any further time. I'll just end with a quote, and this is just a part of a poem which I came across in the internet. I'll just read it out for your benefit. It's called Just a Thought. I may be blind, but I can see the contempt employers have for me. I may be deaf, but I can hear. A health and safety issue here. Mental health, wheelchairs and depression give employers one impression. Got no use and no ability, all because of a disability. I want a job, a life, a chance, but I don't get a second glance. I am viewed as ill or incomplete. All I need is a chance to complete. Thank you, ladies.
Thank you so much, Justice Bhatt. It's my privilege to introduce Ms. Anuradha Mohit. Ms. Anuradha Mohit is currently the Special Rapporteur of the National Human Rights Commission of India on Disability. She has earlier served as the Deputy Chief Commissioner in the Office of Chief Commissioner for Persons with Disabilities and as Executive Director of the National Association for the Blind. She is one of the founder members of the Disability Rights Group and has worked for the enactment and implementation of the Disabilities Act 1995 all through. She has held positions in several disability committees and commissions, among them convener of the Asian and Pacific Network of Women with Disabilities, National Coordinator of Community-Based Rehabilitation Network, member of the Drafting Committee of Persons with Disabilities Act, member of the Steering Committee of the Ministry of Tourism for Barrier-Free Tourism for Persons with Disabilities. She is also on the UN Ad Hoc Committee on a Comprehensive and Integral International Convention on the Protection and Promotion of the Rights and Dignity of Persons with Disabilities. Ms. Anuradha Mohit.
I really do not know where to start. Actually, this is the time to end, actually. Honorable Justices of various high courts of country, organizers of this colloquium, first of all, I think I owe you a very sincere thanks for inviting me, for allowing me to sit through the proceedings. This has been really a great day of learning for me. Especially, I have been very, I would not say feverishly, but with great interest, have been reading some of the judgments out of the hands of people who are sitting here. And I think deem it a very great honor and privilege for me to be having an opportunity to see them, witness them in reality. The judgments, sirs, which you all have delivered have really helped me understand many aspects of disability rights, but has also created new questions in my mind. And when I went to the UN Ad Hoc Committee on behalf of the National Human Rights Commission in 2002, I discovered that I have a great advantage because over the last 10 years, a lot of my education has come from my direct experience of working with people with disabilities on their subject and about changing my reading interests from fictional literature to the judgments out of the High Courts and Supreme Court of India. I felt so empowered participating in that complex and dynamic process of treaty making, and especially when I was invited to contribute to the compilation of the draft which the Ad Hoc Committee would consider for negotiations. A lot of it which you see in the convention, and especially on the social, economic, cultural rights side, I think I would say a huge amount of it is influenced by the inputs which I bring from here, drawing from the interpretations of the High Court and Supreme Court of India. But I think substantial influence definitely there, because with me are many other people who are well acquainted with the kind of jurisprudence that has evolved in our country on that particular aspect of the right. Colin had assigned me the duty to share with you the emerging thinking in the international, I would say, law, or the international thinking. I think the day has been pretty heavy, and so many ideas have been floated, debated, that I don't feel like adding more today, maybe on some other occasion. But I will not fail you, Colin. I will touch upon very quickly 2 or 3 aspects which I think are worth sharing, and where we see that the disability in itself has become such a contribution to the international human rights law, but it has the potential of raising the bar of human rights standards by giving content from a disability perspective to some of the rights which exist today. First of all, one thing which has been addressed a number of times today by honorable judges and many other distinguished participants and resource persons of this colloquium, that is on the notion of legal capacity. Who is a legal person? Who is a person equal before the law, and who has the capacity to act before the law and under the law? We know that the notions about disability and its association with incapacity is very deeply entrenched. And Honorable Justice Vikramjit Sen very rightly pointed out in the morning that the disability-related exclusion and discrimination is perhaps as old as the civilization. And its reflections you see in various legal systems, including our own. Mr. Archie Bhagat has referred to that, Radhika has referred to that, and many others have today. This entrenched legal construction of disability, which actually systematically, takes away the personhood, or I can say, and you will see what Professor Quinn says, that has resulted in the civil death of the disabled. And it takes on examples from the women's experience, and then relates this to the disability experience, the only difference being the civil death in the case of women used to, but not anymore, or at least not to that extent, but used to happen at the time of marriage. And the whole women's movement is all constructed around restoration of the personhood of women, females. But in the case of persons with disability, the civil death happens not only after a person reaches a particular age, but I think it happens exactly with the time the disability happens. The onset of disability brings with it conditions resulting in civil death of the individual. And this process, the international process, I would say, is one example towards the restoration of the legal personhood of persons with disabilities. I do have some slides. Probably I choose a few of them. Mayuri, if you bring me the equal recognition before the law, which Radhika mentioned, and I'm very happy to share with you that over a period of 3 painful years of dialogue and discussion, we have reached at this draft in the ad hoc committee And from the 16th of January when we meet, this will be the basis of further negotiations. And you see here that a very clear emphasis and a very clear actually an obligation towards the recognition of persons with disabilities as equals before the law. In the hierarchy of obligations, recognition may be the softest or the lowest level of obligation, but in the context in which it comes here, this makes it very important actually, this recognition. Related to this is another notion, an acceptance that yes, there may be some people who would require support and to supportive decision making. And the support also is perceived to be proportionate and tailor-made. The support must not be disproportionate and out of context. The ultimate effort is to ensure that no person is deprived of his or her dignity and the autonomy. Autonomy means the ability to take charge of one's own life and decisions, and the ability for relative respect for others' freedoms. I move on to the next slide on this article itself, and the opening statement you will see that the great caution is being exercised even in the suggestion for introducing the concept of supportive decision making. That is seen as the last option, and a last option with sufficient safeguards. Ultimately, in the center of the thinking is the autonomous individual whose dignity must be protected under all circumstances, especially they being so vulnerable to being deprived of their dignity. And the legal personhood, its death and the process of restoration essentially will have to provide procedural safeguards so that this does not happen in future. And also, the most important, I think, objective is that the treaty should tailor these rights, taking into account the circumstances of people with disabilities, by which states are enabled to undertake the process of reform, and also as an aid to the courts in understanding the freedoms and rights in the context of disability and what its implications could be. I think that's the main purpose which the committee is serving. I think this happens whenever a thematic instrument is being elaborated on it, because always the assumption is the rights are same. You're not creating new set of rights, you're only adding content to the rights by taking into account specific circumstances of a particular group or individuals. But this is what exactly we are doing. There is no creation of third generation of rights. A bit of it may happen, and that I would say could happen in another context which I will come, and that is economic, social, cultural rights context. But I will, along with this, try to emphasize that the realization, the positive side of the whole negative experience is that it's so wide and deep-rooted that all across the globe, whether we are the countries from African region, Asian region, Europe, or North America, regardless, this legal construction is by and large, I can say, comparable. The differences are too few, and that is why, though there has been quite a struggle, there seems to be a unanimity now. People want to change what must be changed. And that is why the emphasis is also on access to justice. Because we know the legal construction has also far-reaching implications on people's right to defend their own good. And as we were elaborating this aspect of the convention, for our good fortune, around this time of the year, exactly last year, November, December, the South African court was looking at a case of rape of a minor with mental disability. And we were watching it with great interest because the question of her testimony was in the center and at a very critical stage. And to our good fortune, an excellent milestone got established just around same time last year, where the South African court allowed a testimony of a mentally disabled girl. That was the basis which we could use in formulating the access to justice, what comes there, and also it comes with a number of concerns. Mr. Rastogi mentioned that the blind people in India, each time they have to open a bank account, they have to wage a war with the banks. Each time we have to acquire a checkbook, you have to fight the system. Everyone else can possess a locker in a bank to keep their valuables, but not the blind people, perhaps who need it most. All the understanding. At times, you go to the bank and they say, open a joint account. It will be beneficial. Someone else or your family can sign the checks and there won't be any problem. And when you go with a family member, they call you and say, I think it's very risky for you to open a bank with a family member. What if they don't inform you and check out all the money? And same goes true with the statistics discussion which came and a little bit distracting. But just wanted to share with you how government used the argument of statistics, and that's why I was saying in the morning, forget about numbers. When there are people, the essential thing is that they have rights which we must recognize. Even if there is one person with mental retardation or one person with mental illness, that does not disenfranchise this person because he is only one or she is the only one. The numbers are not important when we talk about rights, but they become quite important when you look at the policy decision. And interestingly, I'll give you one example, not from India, but from many other countries which many disabled people have shared with me. You know what happens when you say you're 50 million, and then you go and say, you see, the unemployment allowance under the Disability Act varies from rupees 100 to 500 across the country. How can a person, adult, survive during the period of unemployment with 100 rupees a month? The answer then is that you are too many to be considered for a higher unemployment benefit. That's a too huge burden on the exchequer because you're too many. Now, you go and argue with the Ministry of Railways, Surface Transport, and so on, making out a case that under the Disabilities Act you have an obligation to allow wheelchair access. So the buses, the transport systems must be remodeled. The answer is you are too few to call for such a huge investment. Statistics are used in both ways, and that is why Justice Shivraj Patil so many times emphasized in the morning that there is a need to position disability within the paradigm or the framework of human rights, because then at least you can keep aside the argument of usefulness, the argument you cannot bargain rights on the logic of cost. I think disability requires that statistics be kept kept on the back burner, and the rights are brought right in the forefront. I'm going to skip some of the things which I wanted to talk to you about. From the legal capacity, again, the question of liberty and security of the persons, hugely important, which came so clearly in the presentation of Honorable Justice Ajit Shah in the morning, where he was narrating a case and an incident coming out of that a person was sent to a mental home at the behest of the brother, who asked for an intervention from the court in this regard. And the person ended up spending the entire life in a mental home. The NHRC has many cases which could be shared, and the famous one would be, I think, the Agra mental hospital home, where the man was sent to the mental hospital without any history, even shown dead in the records. And when you dwell deeper into the case, what one finds is utter greed for someone's brother to act in this fashion. The only interest was to grab the property, to hog the property of this brother who was sentenced to, not sentenced, but assigned to a mental hospital. Of course, the system connived with this man. And then last year again, I think last year or 2 years ago, 10 women, again the Tehilka brought to fore this case where again Agra Mental Hospital was under controversy, and one psychiatrist was issuing certificates of mental disability, assisting the men seeking divorce from their wives. I couldn't understand, I have yet to understand that whether this is used as an instrument to expedite a divorce decree or to get rid of the burden or responsibility of paying maintenance. Because under the Hindu Marriage Act, if the marriage would be annulled on the ground of insanity, then is the man liable to pay any maintenance? I have not seen denial of maintenance, but what interests me most is that maybe we need to look at it very carefully and see two things. How many men have used the insanity ground in expediting the divorce petition, and how many women have done it? My comment says it is more men who use this over women. So such constructions have implications on the rights of other vulnerable groups. Both the mental hospital case, Agra case of the man out of payment of property, and these 10 women, I think both point to the fact that these legal formulations are a deterrent to the well-being of other marginalized groups as well. So it's better, I think, the reform is looked from a much broader perspective than from the perspective of disability alone. And we have such an excellent jurisprudence. I am not quoting those examples, but Rameshwari Devi versus Rameshwar Gupta is an excellent case, and I have read it so many times and I've shared it so many times on a number of fora in India and abroad, and people seem to applaud and appreciate what. I'm sorry, I do not have it with me, but the question of deprivation of liberty, which a number of other speakers pointed out, and done a critique of Mental Health Act, which is concerned more about how the admission should take place, whereas the emphasis is, I think, on the right side. The voluntary admissions are more encouraged than over involuntary admissions. So that sense, the Mental Health Act is positive, but the negative of it is that when it comes to discharge, the individual doesn't have the freedom. A third party has to file an application for discharge in case this is a voluntary discharge being sought. And this does not happen in other areas. And there were, for a long time, we believed and associated mental disabilities also with the danger. And my eyes were open. Few years ago, through these interactions and by going through literature and seeing a very interesting statistic which said that in Canada, the deaths, the incidence of suicide, homicide on account of insanity were fewer than the incidence of deaths on account of lightning. And there is another question that this happens, as somebody was saying, that first let me commit the offense and then start the due process of the law. But what happens here, most detentions, no more, but in many countries even today, most detentions happen on an apprehension that a person is dangerous. Because the association of danger with mental illness is so deep and so wide. Somebody asked a very interesting question. I was talking to faculty in Punjab University, Chandigarh, and this lady raised a very interesting dimension, perspective, and she said, Haryana and Punjab have a dubious record of dowry deaths. Can we apprehend the Punjabi men because they have a tendency to indulge in criminal offences? Road accidents in Delhi are very well known. The killer roads of Delhi and the reckless driving. But do we apprehend drivers because they may kill someone? But here, the law provided justification for deprivation of liberty on an apprehension that a person may be dangerous. But who decides the person is dangerous without any first-class evidence to that effect? And that is why this is the whole effort of international convention is to allow the reform which is required to change such practices which are quite arbitrary and archaic as well. The liberty had two things, and that's why a compensation is very important aspect added to this aspect of the convention, which is not under ICCPR. It is there, but association with a disability had to be clarified, and a compensation had to be provided for in case. I'm now shifting from civil rights suddenly to another arena, because interestingly, the whole convention's elaboration is happening at a time when the whole world is going through has adopted, I would say, market economy, is working on the principles of market economy, and market economy essentially means privatization of not only businesses but of essential services as well. Maybe can you take me to the general comment number 5 of CSER, the first slide of the general comment number 5. It's an interesting interpretation from the Committee on the Economic, Social, Cultural Rights, which one could use as an important guide, in addition to what the way, in a most creative and progressive fashion, the Honorable Supreme Court has elaborated right to life and in fact included everything which is under directive principles, considering it as a fundamental right or important element of right, the life-related right. So we could use that, but for us it was more important to look for international jurisprudence and international interpretations of private freedoms, because the convention which I am talking about is it's a comprehensive convention. It's covering covering all aspects, including economic, social, and cultural aspects of rights of the disabled. And it could have been such a failure on part of the international community to talk about rights of the disabled from that category without taking into account that when ICSCR was elaborated, we were a different kind of world in terms of structures and economic systems. Now we are a different kind of world from there. So the contemporary world's reality is private. So if private is the reality, can private be held accountable under an international legal instrument? We saw the precedents established under CEDAW when it talks about protection of women against domestic violence. So the precedence is there. Domestic violence, I think, the most difficult to monitor. If somebody has to monitor that obligation under the international law, but we know that owing to the wide practice, there are systems established throughout the world and the national legal systems by which protection is afforded when that violence happens in the domestic arena. But in the context of disability and economic, social, cultural rights, we had to expand it a little further. Reason being too, if we look at the example of India, I saw all the 9 5-year plans from Plan 1 to Plan 10. If you look at them carefully from a disability perspective, you see that our plan has 2 focus areas. One, that it makes a commitment or plans the budget for creation of human resources. The persons who would service the rehabilitation services. And the second is the grants for NGOs. It means that the government has a clear emphasis on delivery of basic goods and services meant for the disabled through the mechanism of NGOs. If the NGOs are the delivery systems, then they are the private bodies. Should they not be held accountable, at least to the equality and non-discrimination norms? Should they be allowed to discriminate? This is what Radhika mentioned, that there is no regulatory mechanism. There are no standards agreed and applied. So differential treatment is everywhere, and it places numerous examples of discriminatory treatment within the private sector. So what this convention is doing, Mayuri, can I look at the article on access in the convention? It has a standalone article in the convention on accessibility, which has not happened in any other convention. This is what I was referring to as a third generation of right. But it's not actually a third generation, because access is part of the international law discourse and even the domestic law discourse. It comes from 2 concerns in the legal systems. Concern of cultural and attitudinal barriers. I take the question of Dalit, etc. into account. Then the question of, in opposition to the cost barrier, the poor people and the women, they may have less access to public infrastructure because of their gender and other conditions. And I think this notion is very aptly provided and aptly captured in the Constitution of India. If you look at Article 15B, the Article 15B and what is coming in the convention here, I don't think there are major differences, because Article 15B talks about non-discrimination in the matter of access to public places, and then imposes a positive obligation on the state for introducing special measures to ensure access by women, children, educationally and socially backward classes. So this formulation in the international law is very much comparable with what we have under our constitution, and it's also comparable with sections 45 and 46 of the Disabilities Act, but it's quite another thing. It is quite another thing that that aspect of the Act, actually a justiciable aspect of the Act, is linked to the economic capacity. I do not know out of what concern, but it is, I think, the failure of our disability movement that they have not brought any petition before any High Court, not even a complaint case before the Chief Commissioner or before the National Human Rights Commission. Because if you look at the Constitution and you look at the 45, 46 and the question of access, I think there's a real compatibility. Act has only elaborated on what is there already in the Constitution, and very much a justiciable right. But what has happened is that I was trying to address the other thing was that the contribution of the disability to the notion of access is a unique one, because the access in the Constitution is concerned with those attitudinal barriers and cultural practices and the economic disparities. But the disability dimension has brought another dimension of access to fore, and that's the design of the infrastructure. The way the infrastructure is designed and used, especially, again, I go to the Gerald Quinn's study from the Office of High Commissioner for Human Rights. It says all points of access to the world of work, to the world of education, even social interactions are set largely by the norm of able-bodied. So the disabled would be excluded naturally. What it's trying to do is trying to now bring this dimension to force. The test lies in convention, of course, is bringing it in, and with it, it is bringing another obligation in the convention. Mayuri, do I have the private entities? I am going to finish it over there. Yeah. Okay. So the clear obligation which is coming through the Act is on the private sector, though in a very limited manner, and that is going to be when the information in the public domain and the services in the public domain are delivered through private entities, they be subject to non-discrimination and equality norms. So we're going to see that expansion, further elaboration of that notion of principle of access, I should say. I think those are the significant contributions which the disability is going to make to the human rights discourse, and which may have a very positive impact on the way the law is developed and would be reformed at home here. But I think before that reform is initiated by the government, our judiciary is more proactive, and we've already seen some of very progressive, interpretation of the Disabilities Act. And hopefully, by the time we complete the drafting of the convention, which will be most likely by the end of this year, the coming year, 2006, or by the middle of 2007, India would be in a very good position to initiate changes under the convention if it signs up to. Right now it is participating, so I'm quite optimistic that it will play a very positive role even post-convention scenario. Well, thank you very much for your patience. This is the end of the long and very rich day, and I'm extremely sorry that I brought in the discussion on some of these aspects at this point of the time under the circumstances. I'm the slave of the circumstances. But thank you very much for letting me there.
Before you start the concluding process, I want to say a few words.
Yes.
I am S.N. Hussain from Patna High Court. We were invited for a colloquium, but in the second half it appeared to be National Judicial lectures only. Most of them were quite informative, but a couple of them were not befitting the occasion, to say the least. I also want to say that Dr. Bhagat has said that law is not sufficient and existing law is defective. Then you should have gone and tell the same to the lawmakers. We have to decide as per law, but we have been passing orders expanding the prospects, resulting in judicial activism, as you all know. But someone has to bring the facts before us about non-functioning of the bureaucrats. Some of the NGOs, no doubt they are doing very good work, but most of them are doing their personal aggrandizement. You must acknowledge it. If no one is doing anything, how can we be expected to be the last resort? But I do not blame him, as he appears to be one of those having fixed views without understanding the judicial system. I do not want any answer from him. But I want to ask a question from Ma'am Al-Qazi. She has really impressed me. But whether she is here? It's no colloquium. That's all. Thank you very much. Sorry if
without defending any of the speakers, and we tried our best to make it. We thought that there needs to be a convergence between the judiciary and the civil society, especially on these kind of issues. That was how we planned. I think Dr. Bhagat made the point because he felt we have seen that the buck has been stopped.
Civil society. We are part of civil society.
Doctor said we are part of society.
I accept that criticism, and we
it's not criticism, it's a fact. You see, that we belong to civil society, it's a fact, it's not a criticism. Okay.
The buck has been stopping at the judiciary. I think that's how Dr. Bhagat could make that kind of a remark, because the judiciary has not failed when other organs of the government have failed. And with that, I invite, thank you, sirs, for being with us for the whole day. It's been a long day. I invite everybody for the tea, and a very good evening to everyone. Thank you.